kids or our children into this child labor, as well as the widespread, this financial hardship, and it's something we have to look at. Again, one of the causes can also be discrimination, that is unequal social guidance. So that is, Mr. Speaker, you would realize that some of our family members who feel that they are in so much hardship will now take their children to stay with other parents, and by the time you realize some discrimination among kids, they deny them also access to education and also get them into doing things that at their age they are not supposed to be engaging in. And so it's to us as stakeholders to make sure that I would appeal to the government to continue to enhance and encourage him in terms of the policy making. But Mr. Speaker, the maker of the statement clearly stated that there has been a huge demonstration in the commitment of eliminating the child labor through the enactment of the key legislation. But still, these menaces are still happening. And so I would ask my colleagues that let us be practical about this work. Practical in solving child labor. That is, wherever these institutions are, we have our leaders, either appointees or some leaders that we can collaborate and engage with. So where do you find kids working in agriculture? It is in our constituencies. And we have assembly that takes care and assists in the constituencies. So we get the agric director in charge there who have its own, directors that will be going around, or officers, agric officers that will be going around. They should make sure that when they find kids or a child underage between the age of 5 to 17 years, they should report and get them to put a stop to that act. Again, when we find or we talk about mining sectors, we still have our local leaders over there, teachers as well. So, Mr. Speaker, I would say that much also dependent on us as parents and leaders. We brought the case on this earth, and we should take it up. It is not about the book. It's about the practical work. We have to make sure we put in measures, and also the security agencies that have to put justice into place should do that. And I believe that with that, we will find a better way in solving. Thank you, Mr. Speaker.
Thank you. I'll take the last one. If there's nobody here, then I'll take Kintampo.
Thank you, Mr. Speaker. I'm grateful, and to the maker of the statement for this laudable decision. Mr. Speaker, I have been attending programs a lot, human rights programs, educational programs, and what have you. And annually we are talking of child labor, child labor, child labor. Mr. Speaker, I beg to differ today a bit. Can we begin to relook at the causes of child labor well as a nation and beyond? I take myself, for example, Mr. Speaker. I was very young when my mother and my father had separation. I was moved to my senior father at a community called Asantequa in the Kintampo North Municipality. My senior father was a young farmer. He never forced me to start using the hoe. But at a point, I was gingered up on my own to tell them that I wanted to farm. And he permitted it at a point. Mr. Speaker, the end result about this is that at my secondary school, during economic recovery program, my father was affected. I didn't have money to continue. But because I knew how to use the hoe already, I used to tell our assistant headmaster, who used to farm, that anytime he plowed, he threw his 2 acres farm He should never give it to Bade people. And Mr. Speaker, to put it on record, I used to be able to farm 1 acre every 3 days to claim the money to support myself in education. The speaker himself, the Speaker of Parliament, one day he told me, he said, look, they used to move from Upper West through to Kentampo to other places to do what they call jong. In Dagari, they go to collect by day. Honorable Chiwite is just seated there. That is how they all grew up, in learning how to farm. We should begin to look at some of these figures. If not, the international community will continue to throw figures at us and will leave our culture away, follow their figures just for following sake. I joined the Ever people on the Bamboy River. I did what they call Gbadodo. I was a very young boy in primary school. We go in the night at the river and do what we call haro. That's how I can speak Ever. At that point, if somebody saw me, the fellow would say I was doing child labor. But indeed, that wasn't child labor. I used to do it the next day, get money for school. And today, I am blessed to be here. For me, I'm beginning to think that we do statements, yes, that is the right thing to do, but we should begin to look at these statements and the figures that the international community and NGOs are championing for us. My last one, Mr. Speaker, I was at a human rights program. They came out with a woman, a pregnant woman, with a child going to the farm. The mother was carrying firewood, and the child was holding the cutlass. For all you know, in that community, the senior brothers who can walk some 2 kilometers to the nearest education facility, they were in school. Should the woman leave the small child in the house alone without walking with her to the farm until he gets to the stage where he can also follow the brothers? Lack of educational facility. So if an NGO come to this community and see this and come and tell me that and write that fellow's name, that the fellow is child labor, the every man send the child to the river to know how to fish so that in future he can survive on his own, then we say it's child labor. Mr. Speaker, I'm sure we need to begin to look at some of these figures again. And culturally, let them know this is how we'll bring up our children. Yensan Kofa to wait. Let's go back to our root. In Accra, if you go to Circle, it is flooded with people under the bridge, the overhead. Once in a while, they come to some of us to beg, and I tell them, where are you from? Uko Kruma, Abe, Koshas, Yesan Kofi. Don't sit in Accra to wait. Don't be here begging. Very able-bodied guys are using this to wipe cars. They wipe the moment you are parking, Tema Road or wherever, they bring this ash foam and things and try to wipe your.
Thank you very much, Honourable Member for Kintampo, for taking another angle of the discussion. Of course, all of us went through some of these things. So I'm inclined to also go with him. So, honorable members, we bring statement to a close. We will now move to the bill. So I will invite the first deputy speaker to take the chair. Anyway, let's move on. So whilst he gets ready. So, consideration. So, Community Service Bill 2026 at a consideration stage. So, honorable members, I think the last time we were considering, we did up to 39. 39. So we'll be moving to clause 40.
Honourable members, Community Service Bill at consideration stage, starting from page 14. Proposed new clause standing in the name of Osahin Alexander Kwamina Afanyomakin. Yes, Honorable Jerry Ahmed.
Speaker, which of the proposals are you looking at, please?
At page 14.
Yes.
Yes.
Speaker, I move on behalf of the Osayin Alexander Kwamina Afenyomakin, clause 1, after clause 39, the amendment proposes as follows. After clause 39, add the following new clause. 1. In exercising its discretion under section 39, a court shall be guided by a presumption in favor of a community service order where a convicted person is a first-time offender, a person with primary caregiving responsibilities for a minor child or a dependent adult, a young person between the ages of 18 and 25 years, or a person with a certified medical or mental health condition that makes custodial sentencing disproportionate. Speaker, 2, where a court decides not to make a community service order in respect of a person falling within subsection 1, the court shall state its reasons on the record. I so move. Thank you.
Yes, before giving the floor to the chairman of the committee, I would want to say that when the amendments are exceeding certain number of lines, you just indicate as captured by page so and so of the order paper.
Speaker, I'm very well guided. So,
yes.
as captured by page 14.
Yes, that's the proposed amendment, and it is for the consideration of the House. Yes, chairman of the committee. Yeah, when it exceeds 4 lines.
Mr. Speaker, I am opposed to the proposed amendment which stands in the name of the minority leader. Mr. Speaker, if you read clause 43 and even clause 44 of the bill, Mr. Speaker, would find that everything, all the, matters raised in the proposed amendment have been well dealt with. So, for instance, you take the 3rd line of the proposed amendment, which talks about a convicted person is a first-time offender a person with primary caregiving responsibilities. And then it goes on and talks about a person with a certified medical or mental health condition. Mr. Speaker, you find all these things captured in 43, 1, A, I. And 43, simply, Mr. Speaker, the heading is Social Inquiry Report. It reads as follows: where a court determines that the community service order should be made under Section 45, the court shall, before making the order, direct, Mr. Speaker, with amended probation officer, so community service officer, to conduct a social inquiry into I, circumstances of the case, II, character and antecedents of the convicted person. So what the circumstances of the case and the character and antecedents of the convicted person would include issues to do with whether or not the convicted person is a first-time offender, is a primary health care giver, and so on and so forth. The comprehensive social inquiry report would usually cover all those things outlined in the proposed amendment. As for the II, it actually talks about health status of the person. Mr. Speaker will find that the amendment seeks to say, or a person with a certified medical or mental health condition. This comes under III. So, Mr. Speaker, if you read the bill as a whole, you find that this proposed amendment is unnecessary. And therefore, I would urge that the said amendment be abandoned forthwith.
Yes, Honorable Tim Fojo.
Thank you, Right Honorable Speaker. The proposed amendment is very, very important to stay because it provides clarity, specific circumstances, which Section 43 or Clause 43A and B do not sufficiently provide for. Because Clause 43A only talks about the circumstances of the case, the character, antecedents of the convicted person, the health status of the person. But this amendment goes to detail the specifics. Yes, we are leaving the discretion of community sentencing at the discretion of the judge. But it is important that we also provide the specific circumstances which must guide the judge presiding. And here clearly, in exercising its discretion under 39, a court shall be guided by a presumption in favor of a community service order where a convicted person, 1, specifically a first-time offender, 2, a person with primary caregiving responsibilities, 4, a minor child or a dependent adult or a young person between the ages of 18 and 25 years or a person with a certified medical or mental health condition. So here the health condition has even further, there's a new dimension has been introduced, which is the mental health of the offender. So this is a more encompassing, more specific bill. That, Mr. Speaker, as we always take your popular guidance, that in crafting, you need to be as specific as possible on exactly what you are legislating. So in that principle, Mr. Speaker, I would urge the House to adopt the rendition.
Yes, with proposed. All due respect, can we look at the rendition as against Clause 44 of the bill, which set out the conditions for making community service order? It specifically spelled out the condition based on which the court will grant a community service order. And we want to do away with this to accept a presumption.
Thank you, Mr. Speaker. So the additional conditions that are provided for under 44 do not overlap the amendment proposed. They will be very tenable additions to the provisions made under 44. even combined with 43.
So you want it to be a new clause, or it should be a
Very much
proposed
so.
amendment to 44?
Because
Because 44 is setting out the condition based on which the court will grant
Yeah.
a community service
by your
order.
guidance, we can add it to 44.
So if clause 44 is setting a condition, and you have another clause, which is saying that it should be based on certain presumptions, when the conditions based on which you are going to act is clearly spelled out, you cannot make a law to say that it should be based on certain presumptions.
Mr. Speaker, I agree. So the amendment can come under 44.
Yes, Chairman of the committee, I feel there is no need.
Mr. Speaker,
Yes.
in addition to the arguments I've already made in opposition to the amendment, I just want to draw your attention to, and I'm forward-looking, in clause 44, and when we get there, Mr. Speaker, we even have yet another proposed amendment. And that amendment seeks to, it's at subclause 1, paragraph D. And what it says is that delete is a habitual convicted person and insert has a previous conviction. You see, so it adds more flesh to what is already captured under 43, where, for instance, the health status of the person must be taken into consideration. The character and antecedents of the convicted person must also be considered, as well as the circumstances of the case. So you don't want to unnecessarily restrict what the social inquiry report would contain. There should be flexibility. But so normally, when you are seeking to get officers to conduct social inquiry reports, you allow for flexibility because there are issues that may come to the attention of the social worker or whoever is responsible for churning out that report, which cannot be legislated. Or we've given a broad framework, which can be found in 43, with specific guidance provided for in some of the specific issues mentioned. So, Mr. Speaker, I think we should.
I agree with your earlier guidance that the 44 sets out the various conditions. And so any amendment that seeks to introduce new factors for consideration should come under the 44. So that guidance, I agree. And that is why I propose that the 44 conditions that they set out, plus the 43 conditions that my respected chairman sets out, are still not exhaustive of the specific factors raised in this amendment. So I propose that we lift those amendments.
Please again drawing your attention to a proposed amendment that has taken care of this.
So, Mr. Speaker, I propose that we carry those amendments under 44, where we enact that the convicted person, the presumption in favor of the community service order, whether the convicted person is a first-time offender or a person with a primary caregiving responsibilities for a minor child or a dependent adult or a young person between the ages.
My question remains unanswered. If a law stipulates a condition based on which something is supposed to be done, do you need to have another provision apart from those conditions basing it on presumption? Because in the absence of specific conditions based on which you should act, there can be a presumption. But when the law is telling you A, B, C, D should be a condition for you to make a community service order, you can have a provision that will subject the same condition to a presumption.
Mr. Speaker, the suggestion from the member is that the 44, clause 44 is not exhaustive. So there are some conditions that...
So then the mover of the motion should do the needful when we get to 44. and you are still not
He's saying that
satisfied,
it's not exhaustive.
then-
So he thinks that some of the amendments that they are making under 39, which falls under condition, should be moved to 34. That's what he's 44. That's what he's saying. So that it's very exhaustive, especially caregivers and a few other people. That's what he's trying to say, Mr. Speaker.
Yes, Majority Leader.
Well, Mr. Speaker, what the amendment proposed by Honorable Afenyomakin seeks to do is not to add to the requirements of Clause 44. It is to create a right to be vested in the case of a first-time offender, okay? First-time offender, a person with primary caregiving responsibilities for a minor or a dependent adult, a young person between the ages of 18 and 25 years, or a person with a certified medical or mental health condition. So these four categories of persons, what the amendment seeks to do is to create a right for them that when they commit the offenses specified in Clause 40, for which community service is an alternative, in their case, there should be a presumption that they are entitled to community service. To do, okay? And the chairman is saying that indeed we have considered some of those categories. So if you go to Clause 44 and the amendments proposed by the committee itself, it clearly also adds in the category of 44 some consideration regarding, for instance, a nursing mother, some consideration regarding the principle of not separating a mother from a child, and I think another one that perhaps caters to the needs of health and other considerations. I think the committee makes that recommendation in 44. So the idea then is that drop 44, which in effect creates a right. And if the judge is not doing, the judge must explain. To adding some of those to 44 so that the judge can consider them, but not as a right. Because if you say a presumption in favor of those categories, in effect, it creates a kind of right that I'm entitled for you to give me community service. If you don't give me community service, it's your duty as a judge to explain. But in 44, the judge is being told that in taking your decision, you may consider A, B, C, D, E, F, G, H, including the condition of the person in terms of health, the condition of the person in terms of age, the conduct of the person in terms of previous conduct when bail was given to the person, how the person behaved, and all that. So I think that is what Speaker is saying. Let's drop, 39 amendment, and then when we go to 44, we will take all those four categories and see if we can just capture them as part of the considerations that the court should have in mind, but not to present it as a right, because that's what a presumption does. A favorable presumption kind of confers a kind of right. And if you don't let me enjoy the right, you have to explain on the record. Yeah.
Yes.
Mr. Speaker, thank you. Mr. Speaker, I believe that the first part of the argument is accepted, that we should move it to 44. But in passing the laws, I believe that we also need to give a very restricted
space for judges to be very discretionary. Otherwise, we would have had the purpose of making sure that we have a lot of community service. By the end of the day, the judges will also turn them into custodial sentences. So I think that we have to give a small space for them to maneuver. So I believe that where these specific provisions have been made by Honorable Markin, that we need to look at these specific issues. I think when we get there, we should actually consider them and make them very specific.
Yes,
so
but regarding the point that you are making, judges are given the discretion because as a lawmaker, you won't have the opportunity to know the demeanor of the person even before you. And there are a whole lot of factors that they take into consideration in pronouncing judgment. Hence, they need the discretion within which they would operate. So it is always good to give that discretion to the judge. Yes, Honorable Baba Jaman.
Mr. Speaker, we must all bear in mind that there's no way you can make a law that is completely exhaustive. So in making laws, sometimes you create a platform where all other issues can be considered as you are taking a decision on them. So when you look at 43, as it is stated in the law, what is the purpose of 43? 43 is saying that when a court decides to commit somebody to community service, the court shall, and they made it mandatory, shall order a probation officer to conduct a social inquiry. Mr. Speaker, a social inquiry will uncover all the circumstances of the person. Whether the person is sick, whether the person is a caregiver, whether the person is a convicted, old age, whatever. A social inquiry will encapsulate all that. So that is why I think that whatever the intention of the amendment is captured under the social inquiry. If we want to add one or two specifics, fine. But when you look at the social inquiry uncovers everything around a person who is coming to be convicted, and it gives the court the opportunity to ensure they are fair to the person. So I don't think that repeating it here will make any impact on the law. The law is already where, from 43 already captures what we want to do, and that gives even the judge a better circumstance to understand the issues and be able to make a good decision.
Yes, I'll take that as the last comment, and if they still insist, I'll put a question.
Because the social inquiry, apart from the inquiry, can you make it no?
Mr. Speaker, because of what you have said, I think we need to relook at, in combination with what the majority leader has said, we need to relook at this particular clause and ask whether we should allow it to stay or we should move it to 44 as a condition. Condition is not mandatory. The judge may look at it or may not, but he will be guided by it. But, Mr. Speaker...
No, here,
yes,
the law is saying shall.
Shall, okay, that's fine.
It's saying shall.
So it's
a mandatory conditions.
Look at it.
But
the
Mr. Speaker, proposed amendment is talking about some presumptions.
But, Mr. Speaker, like he said, under 39, we are giving the judge some discretionary powers. And he's saying that there are some three conditions, there are four situations where he thinks that in looking at the discretionary powers, you want to take away the discretion of the judge. He can do it, but he must explain. Because the presumption is that this particular four categories of people should presume to enjoy community service first. That's why he's trying to say that, look, when it comes to these four groups or categories of people, they should enjoy community service first. First-time offenders, this, that, enjoy community service first. If the judge decides in his discretion not to give them community service, then the judge must explain why he's not giving them community service. The suggestion is, we are making a suggestion that we should move it to the conditions. Those that don't fall under, like the first time offenders is already under the condition. But the other three, we should move them to the conditions. Is it the same?
That is why I'm saying that if we get to 44, then you can look at the relevant conditions under 44 and see which one is not captured and will have to be captured. I believe we've all listened to Honorable Baba Jamal when he was explaining one of the provisions, what it entails. So the question therefore is, do I put a question on the proposed amendment, or the mover will do the needful? Well, I'll put a question. As many as are in favor of the proposed amendment say aye. Those against say no. The noes have it. Definitely, the proposed amendment is not carried. So, again, amendment after 39, that is at page 15, II.
That's all, Mr. Speaker. As you rightly stated, amendment after 39, after page 14. This one is on page 15 of the other paper, and it is II. An amendment proposed is as follows. After clause 39, add the following new clause. Into parentheses, and I quote, community service inspectorate. 1, there is established by this act an independent, well, so yes, as captured, Mr. Speaker.
Honourable members, the amendment is for the, okay, you want to give reason? Yes, you are done. Yes, Majority Leader.
Yeah, Mr. Speaker, I think this amendment is caught by Order 1683C, Roman numeral 2 of our standing orders. So the 1693C, where it says that at the consideration stage, the House may effect such amendments as the House considers necessary, except that the amendments, including new clauses and new schedules, shall comply with the following. A, the amendment must be relevant to the subject matter of the clause to which the amendment relates. And here I'm relying on Roman numeral 2, which says, no, sorry, not Roman numeral, CII, which says the amendment must not be inconsistent with any clause already agreed to or any decision already taken by the House. Mr. Speaker, if you look at what the amendment is seeking to do, it is seeking to replicate the creation of an institution to perform functions that we have already assigned to the Secretariat and the board and the various regional committees. So if you take, for instance, the first item, 2A, the inspectorate, so it says there is established by this act an independent community service inspectorate. If you go to 2, it says the inspectorate shall monitor the implementation of community service at the national, regional, and district levels. Monitor. This is a function that if you look at clause. Yeah.
Yes.
Speaker, I thank leader for bringing this to our attention. I think that the right thing to do is to abandon it at this point. Thank you.
Very well. Honourable members, the new clause as in II at page 15. is withdrawn. Now we go to clause 40. Amendment II at page
Offenses
16.
suitable for community service.
Amendment II. Number 3 at page 16.
Speaker, thank you very much. Speaker, on the order paper 16, page 16, amendment proposed as III, clause 40 as is captured, we add the following new subclause. 3, the Secretariat shall, not later than 2 years after the commencement of this act, and every 3 years thereafter, review the categories of offenses to which a community service order applies, and submit a report with recommendations to the minister, who shall lay the report before Parliament. Mr. Speaker, I move this amendment on behalf of Osayin Alexander Kwamina Afenyomakin. Thank you.
Yes. Have you considered the fact that clause 40 is on offenses suitable for community service? The clause 40 is talking about offenses suitable for community service. And how do you juxtapose this under clause 40? What you are proposing, that the Secretariat shall not later than 2 years after commencement of this act, and every 3 years thereafter, review the categories of offenses to which a community service order applies, and submit a report with recommendation to the minister, who shall lay the report before Parliament. And I'm saying that clause 40 of the Community Service Bill is under the marginal note, offenses suitable for community service. How can this be an amendment under offenses suitable under community service? Look at the main bill and the proposed amendment.
Speaker, I think that is just to the effect that when you look at the main bill, it talks about offenses, and therefore, if there is any review of an offense with reference to the category, maybe that is why the proposer put it.
I think this provision is dealing with the Secretariat.
Speaker,
it's imposing
yes,
some obligation on the Secretariat.
Yes, Speaker, that's
so
the
it cannot come under community service, offenses suitable under the community service. This relates to the Secretariat.
Speaker, but is the offenses and dealing with the review of the offenses, would it not come under the Secretariat? Because, yes, because...
See, it's saying that offenses suitable for community service.
Yes.
That a community service order made under Section 45 applies to an offense punishable by a term of imprisonment of not more than 3 years, with or without the option of a fine. Despite subsection 1, a court may make a community service order in respect of an accused person who has been convicted of an offense under the enactment which provides as punishment for the offenses a fine only, a fine with an option of a term of imprisonment, or a fine and term of imprisonment. This is what the section is dealing with. You understand? Now, under that section, you want us to place that the Secretariat shall not, later than 2 years, offer community, 2 years after the commencement of these acts, and every 3 years thereafter, review the category of offenses to which a community service order applies, and submit a report with recommendation to the minister who shall lay the report before Parliament. Even if there is going to be such a thing under the offenses, can that be a way of doing it? The law must come to Parliament for amendment?
Speaker,
Yes.
I think that if you read this present amendment being proposed, which may have to be subjected to further amendments to clarify the language, I think this is like an additional function. And so we may have to push it to the secretariat's function.
Exactly.
Which will be contained, but it has to be the secretariat shall within 2 years.
You
after
see,
the commencement of this
it
act,
is only when we get there
then we
that we
can
can tidy
do
it
this.
up.
So you may have to abandon it here and take it to another.
Speaker, I wanted to say I take a cue. We can have it deferred, and then when we get to the functions of the secretary.
Yes, but let's consider the feasibility of it. The law
But
is
Speaker,
stating...
you are the same person who is saying that we are not dealing with it now. If
Yes,
we are
but
deferring
let's...
So let's get the...
No, I'm just saying whether this can be feasible.
Very well.
Even under the provision.
Yes.
In the sense that this law passed by Parliament is indicating the category of punishment that can be subjected to community service. Then Parliament will again make this particular law, giving power to review without the law coming to Parliament for amendment. That is problematic. Yes?
I agree with you entirely. The point is that clause 40 of the bill is very clear, and it talks about, and let me read, a community service order made under section 45 applies to an offense punishable by a term of imprisonment of not more than 3 years, with or without the option of a fine. Now, these offenses, the category of offenses envisaged under clause 40 have already been provided for under the Criminal and Other Offences Act, Act 29. So if you now have an amendment which says periodically you would come back for a review, how are you possibly going to review those category of offenses which will now be made subject to community service orders if you don't bring substantive amendments to the Criminal and Other Offences Act, Act 29? So such a review is impossible without an amendment to the existing law, which is the Criminal and Other Offences Act.
Even above all, this law in itself is categorizing those offenses. And Parliament cannot make law to say A, B, C, D and subject that to a review of the minister without the substantive law being amended. The minister doesn't have the authority to make law under Article 93. So we can subject it to the review by a minister.
Speaker, the amendment is fatal. I mean, it should be abandoned.
Shouldn't be just interested in abandoning. It's good to jojo and get some in-depth knowledge on all the matters, rather than just running to abandon the matters. Speaker, I take a cue to abandon it.
Very well. Proposed amendment accordingly abandoned. Then we go to IV at page 16, also standing in the name of Osahin Alexander Kwamina Afenyomaki.
Speaker, I take the amendment proposed by Osahin Alexander Kwamina Afenyomaki, and that is captured on page 16 of the other paper, today's other paper. And Speaker, I read amendment proposed after subclause 1, insert the following new subclauses. 2, notwithstanding subsection 1, a court trying a person on indictment for a non-violent offense may, if the court is satisfied with the interest of justice and the objects of this act so require, make a community service order in addition to or in lieu of any other non-custodial sentence, subject to A, the consent of the convicted person, B, a social inquiry report under Section 43, and C, the specific authorization of the High Court or a Superior Court. 3, subsection 2 does not apply to offenses involving violence against persons, sexual offenses, or offenses carrying a mandatory minimum sentence imprisonment. Mr. Speaker, I so move.
That's the proposed amendment. It is for the consideration of the House. Yes, Chairman of the committee.
Mr. Speaker, I am opposed to this amendment on grounds that, 1, 41 is very clear. It says, and with your permission, I read, despite any provision in an enactment, a court shall not make a community service order in respect of an offense that is unsuitable for summary determination in accordance with Section 179 of the Criminal and Other Offences Procedure Act 1960. So anything that is not subject to summary determination cannot be entertained so far as 41 is concerned. Now, what does the amendment seek to do? The amendment seeks to add a subclause 2, which seeks to introduce indictable offenses. And this is what it says: notwithstanding subsection 1, a court trying a person of indictment on indictment for a non-violent offense may, if the court is satisfied that the interests of justice and the objects of this act so require, make a community service order. So, Mr. Speaker, ab initio, indictable offenses are not supposed to constitute, sorry, can I land? Okay.
I asked him to explain his own proposed amendment to us. And I said so because the amendment is talking about trial. We're talking about trial. We're not discussing trials here. We're discussing penalty after conviction. But everything about how you have couched your amendment is about trial. So he said that notwithstanding subsection 1, a court trying a person on indictment for a non-violent offense may, if the court is satisfied that the interests of justice and the objects of this act so require, make a community service order in addition to or in lieu of any other non-custodial sentence subject to XYZ. I think you are confusing the issues here. Yes, you are confusing the issues here. So let's drop it and then make progress. Let's drop it and make progress.
Yes.
That's the good thing about making laws. We listen to one another. And where some prominence in this decision-making prevails, why not? Speaker, I've taken a cue from the majority leader's submission, and we have dropped this amendment.
Very well. Amendment accordingly withdrawn. I'll put a question on entire clause 40. As many as are in favor of clause 40 standing part of the bill, say aye. Those against, say no. The ayes have it. I didn't put a question on 40. Did I put a question? Honourable members, did I put a question on clause 40? Yes, those in favor say aye. Those against say no. The ayes have it. Clause 40 is ordered to stand part of the bill. Now we are in clause 41 and the amendment is abandoned. So I'll put a question on 41. As many as are in favor say aye. Those against say no. The ayes have it. Clause 41 is ordered to stand part of the bill. Clause 42.
Minister to notify Chief Justice of arrangements for community service.
Amendment number V, standing in the name of Osahin Alexander Kwamina Aponyomakin.
Yes. Oh.
Allow it.
Please,
Speaker,
you have the floor. Move the amendment.
Speaker, thank you very much. It starts from page 16, in fact, page 17, which says that Minister to notify Chief Justice of arrangements for community service. And Speaker, I move this amendment proposed by Osain Alexander Kwamina Afenyomarkin. And Speaker, it starts with 1. The Minister shall, on the advice of the Secretariat, notify the Chief Justice in writing of the district or communities in the country where arrangements have been made and structures have been put in place for the enforcement of community service orders. 2, the Minister shall ensure the community service programs are available in all districts of Ghana within 5 years of the commencement of this Act. 3, the Minister shall, by the 31st day of March in every year, submit to Parliament a written report on the progress towards nationwide implementation, identifying districts in which community service is available, the districts in which it's not yet available, and the steps being taken to achieve availability in those districts. 4, where arrangements for community service are not yet available in a district, a court sentencing a person in that district for a qualifying offense shall consider any available alternative non-custodial measure, including a suspended sentence, a fine with installment provisions, or a probation order before imposing a custodial sentence. 5, if on the expiry of 5 years from the commencement of this Act, community service programs are not available in all districts, Parliament shall, within 6 months of that expiry, review the implementation of this Act and shall consider such amendments as may be necessary to give effect to the objects of this Act. I so move.
Honourable members, that's the proposed amendment. It is for the consideration of the House. Yes, Chairman of the Committee.
Mr. Speaker, the amendment itself, if you look at the clause 1, it merely repeats what is captured under clause 42. The only difference is that the proposed amendment merely seeks to collapse the numbering and put the sentences together. That's all. So if you look at 1 and just oppose that with what we have, the original rendition, Mr. Speaker, is the same. But if you look at the second, that is the subclause 2 of the proposed amendment, which reads as follows: the Minister shall ensure that community service programs are available in all districts of Ghana within 5 years of the commencement of this Act. Sorry, I should think that that is worth considering. I mean, it's worth considering because it sets certain timelines within which, Mr. Speaker, structures should have been put in place for implementation within 5 years. The only problem is that this is a policy issue. But, Mr. Speaker, like I said, that is something that is worth considering. Then we come down to 3. 3 talks about reporting. In principle, there's nothing wrong, Mr. Speaker, if Parliament so desires that the minister reports so that we can be properly apprised about steps taken towards ensuring that the community service is fully implemented as part of our sentencing policy. Why not? But Mr. Speaker, I have issues with the 4. The 4 is problematic because the 4 which talks about arrangements for community service and in the absence of which we must introduce suspended sentence is captured under clause 48 of the bill. Then the 5th subclause 5 is actually in contradiction to what we have under clause 40. So, Mr. Speaker, given what I have said, I should think that there are only 3 provisions which may be allowed to stand. And those provisions are 2, 3, and no, 4. 4 is already captured under clause 48. So 2, 3. But as for 5 and 4, and even 1, because 1 is repetitive, it repeats what we have in the original bill.
So, honourable members, let's look at it one after the other. It's been agreed that the proposed clause 1 is in the original bill, clause 43. Is that also? Clause 42. The original bill as in clause 42. So therefore, there shouldn't be an issue if clause 42 as it stands is carried. Is that not so? Okay.
That is so.
So the rest of the amendment will come as in 42.2, 42.3, 42.4 in that order. Let's pick it one after the other so that it can be clear for everybody. So I'll put a question on the existing clause 42.1. Those in favor say aye. Those against say no. Now we come to the proposed amendment to 42. That will be 42.2 when it is carried. Now this is for the consideration of the House. Yes, Chairman? Yes, Leader?
Mr. Speaker, their proposal was for us to delete 42. But we have already approved 42. So if we have approved 42, there will be no basis for us. So what Speaker is saying is that maybe you should alter your proposed amendments to now consider proposing a new subclause.
Yes.
So your initial provision that delete will no longer apply, but you're just proposing a new subclause.
Why? Because your proposed amendment to 40 as in 1 is the same rendition as in 42. So what you are seeking to do is to add additional clause as in 42, 2, 3, in the order.
Speaker, taking a cue again, so the new clause should rather be add 42.2 and the ones that come thereafter. Yes, Speaker.
So let's pick it one after the other. The new clause as in 42.2. Adding a new clause to 42 is for the consideration of the House.
Speaker, it would therefore mean that we are looking at 42.2, and we are abandoning the first one, that is the minister shall. Yeah, so the new one would mean that the minister shall ensure the community service programs are available in all districts of Ghana within 5 years of the commencement of this act. 3, 4, and 5 are all captured.
It is for the consideration of the House. Yes, majority, Chief Whip.
Speaker, we, as part of drafting style, we avoid the language of ensure, because to ensure, how are you going to gauge it? So you are giving the minister a timeline within which every district, all the 261 districts, should have this law implemented. So I think you are talking about implementation. Because if you are asking him to ensure, how are you going to hold him to it? So what you are saying is that within 5 years upon the coming to force of this act, community service as designed by this framework should be implemented in all the districts. I think that's the tenor of this provision. So we must take away ensure and say that the minister shall implement community service programs in all districts of Ghana within 5 years upon the commencement of this act. Even then, the community service programs, we must indicate that as enshrined in this act. Yes, the community service enshrined in this act in all districts within 5 years. We may not have to add Ghana because the law is for Ghana. So we'll say that in all districts within 5 years upon the commencement of this act. And then that one, the implementation will come with mechanisms, will come with administrative mechanism, offices created and all that. So that one, you are able to gauge it. But if you say you should ensure, yeah, so Speaker, my humble view is that subject to these further amendments, I support the present amendments being proposed.
Very well. So the new rendition will be the minister shall implement the community service program in all districts of Ghana within 5 years of the commencement of this act. Okay.
In all
districts.
Within 5 years upon the commencement of this law. So, Mr. Speaker, I so submit.
In all districts of which country?
Oh, Mr. Speaker, we are enacting the law for Ghana. You have taught me that.
Yes.
Yeah,
but there are circumstances where we use in the country.
Speaker, that day we debated.
Because even in this law,
yes,
I've seen in the country.
Yes, in the country is different from in Ghana.
Yes, so if you are not saying in the Ghana, in all districts.
In the country.
Yes.
I agree with you.
Yes.
I agree with you.
I rise to agree to the first part of the proposed amendment, except to disagree on the period within which the implementation should take effect. 5 years is too long. The intent of this bill is to ensure community service sentencing.
Yes, but let
it's
me ask you a
operationalized
question.
in all districts.
This house.
With alacrity.
This house makes law that legal aid should be in all districts in the country. How many years this? Do we have legal aid in all districts in the country? So it's better to give a commensurate period measurable than to compress it and they will not be able to deliver.
Speaker, I'm guided. And so by the guidance, I propose 1 year.
When I'm saying that we passed this law in 2016 or so, that legal aid is supposed to be in all districts in Ghana or in the country, but yet till today we don't have them in all districts. and it's in excess of 5 years. And you are saying we should do this within 1 year. Meanwhile, the law is just coming into being. They are now going to start implementation altogether.
Oh.
That there have been some lot of consultations with all the stakeholders, and they've tested all the parameters. That may be the reason why these 5 years. If you reduce it to 1 year, 2 years, 3 years, it won't help us.
Yes,
We'll
that
create
is
problems.
my fear.
So I think that we should leave it like that.
Yes, Majority Leader.
You mean they have subjected it to stakeholder consultation? You mean Afenyo Marking has subjected it to stakeholder consultation?
No.
But that's his amendment. He has consulted stakeholders. Which stakeholders did Afenyo Marking consult? Which stakeholders has Afenyo Marking consulted? Very widely.
Yes, I remember.
Let me just speak.
Mr. Baba, I'll come to you. Let me take the other member and I'll come to you. Yes, you have the floor.
Oh, Mr. Speaker, I have not finished. I've
Okay,
not finished.
after him,
Let me
you
finish.
in the Fugu.
Mr. Speaker, we have already passed clause 40. Clause 40 talks about offenses suitable for community service and offenses excluded from community service, 41. What this means is that upon the coming into force of this act, people become entitled to benefit from 40 immediately, because we did not put in clause 40 an additional requirement that if there is infrastructure in your district for the implementation of community service. Once we did not make that provision, ab initio, immediately the law comes into force. If I'm a lawyer representing, a client in a court in Bolgatanga, I'm going to ask the court to consider my client, and apply for community service as an alternative sentencing provision. The court dare not tell me that, but we don't have the infrastructure in which case it would be a violation of the rights of my client. So I don't think that we should indulge the state so that they will have the laxity to say, oh, it is not ready in this district, it's not ready in that district. We may go to the transitional provisions and then give them a timeline. 1 year, 5 months, not regulations, to just make sure that the setup is there. And the setup involves the establishment of these committees at the regional level, at the district level, and the court identifying the community service officer. Those are the main items required. Constituting the regional committees, constituting the district committees, and appointing a community service officer for every district. Once you do that, you can proceed to implement the community service provisions. So I don't want us to give them that space to come and tell us that, oh, we haven't started it yet, so in this district it's not yet ready, and that we don't have money. I mean, that should not be entertained. Mr. Speaker, I believe that once the law comes into force, everybody who is responsible for taking a step to make sure that the infrastructure is there takes it. Let's give them a blanket time. 6 months. Within 6 months, the committee should be in place, the community service officer should be appointed, and lawyers can start applying for their clients to enjoy under this particular law.
Yes, Kobe, let me take, yes.
Okay, Mr.
Honorable
Speaker.
Baba Jamal, I'll come to you. Let me take Honorable Baba Jamal, I'll come to you.
Okay.
Yes, Mr. Speaker, I think that part of my comments had been captured by the majority leader. I would just want to caution that as a country, we should learn how to crawl before we start running. Because too many laws have been passed in this country We have given various timelines and it never works. But this particular law is a very important law that, considering the nature and circumstances of our country, we will need to hasten slowly on it. That's why I agree with the majority leader that we should be careful assigning timelines and forcing the state to do A, B, C. The law itself is structured in a way that certain things must happen before we can go ahead with it. We should allow the system to work itself out instead of putting strict timelines. When we go to the transitions, I think that place we can give some advices. But in the law, tying the state down, I don't think will help this country. Thank you, Mr. Speaker.
Yes.
Yeah, Mr. Speaker, if we take clause 42, it says the minister shall, on the advice of the Secretariat, notify the Chief Justice in writing of 1, districts or communities in the country where arrangements have been made. So clearly shows that some arrangement will have to be made before it can be implemented. And therefore, it is important that we give ourselves some time. If you don't give a timeline, Mr. Speaker, I tell you, this arrangement will be in perpetuity.
So,
and they will never be done.
If you give the timeline, but they didn't comply with it within the time, what will you do? Are you going to create a sanction?
You might have to insert a sanction for that purpose.
Very well. Yes, you can now have the floor.
Yeah, thank you, Mr. Speaker. Mr. Speaker, I was only looking at the heading of Section 42. Mr. Speaker, if you look at the original Section 42, you see that we're just talking about notifying, that is the minister notifying Chief Justice of the arrangements for community service. But now if you are agreeing that we should add the proposed amendment, that is proposed amendment 2 and 3, it means that obviously the remit of that section will go beyond just notifying the Chief Justice. Because now we are even saying that the minister shall implement community service programs in all districts. So we may have to look at also changing the rendition of the subheading to reflect the entirety of the new Section 42 if these proposed amendments are taken. And so maybe I would, if it is done, I would have proposed that we say minister to make arrangements for community service so that everything that comes under it will now speak to that subheading. Thank you, Mr. Speaker.
Yes.
Thank you, Right Honourable Speaker. Right Honourable Speaker, I rise to generally support the point the Honourable Majority Leader is made, but also to indicate that everywhere in the world, community service as a form of sentencing or punishment is done within a certain established framework and structures, which is why I see that 42.1 talks about the minister informing the Chief Justice of certain arrangements and structures being put in place. I just want to caution that I'm not too sure that just by appointing the committee and a community service officer will be sufficient structures and arrangements for community service as a form of punishment or sentencing to take place. Because, for example, if you have a district where you don't, or if you have a district, even a region, where you don't have a prison service and convicts are required to engage in community service as a form of punishment or sentencing, the question of who even supervises the community service, who is going to be accountable and responsible, and all of that. And we are always to remember, Mr. Speaker, most respectfully, that once trial is over and judgment is passed, conviction is made, and sentencing is given or punishment in a form of community service, the remit of the law, you no longer place the post punishment within the framework of the police. It becomes the mandate or remit of the prison service. So I think even the definition of what will constitute sufficient arrangement and structures is important, and also a realistic timeline within which these structures and arrangements can be put in place are also important. And I'm too clear in my mind that whilst I agree with the Honorable Majority Leader that we should not give the executive a blank check, if I may put it that way, to do as they please, and therefore we should pin them down to timelines. We should do so also with clear deliverables. The minimum, in my view, will be a district must have the availability or must have the reasonable means of securing prison officers to administer or implement or be accountable for the execution of a conviction or a sentence in a form of community service. I thank you, Mr. Speaker.
So, Mr.
Chairman
Speaker,
of the committee.
Mr. Speaker, in direct response to Honorable Abu Jinapo's submission, I'd like to place on record that if you go through the bill, the structures we need to have in place in order to ensure that implementation kickstarts are actually the committees. First, you have to have the secretariat. And Mr. Speaker, let me remind all of us that the composition of the secretariat is carefully chosen to address some of the concerns raised by my good friend, the Honorable Abu Jinapo. You have prisons officers, you have police officers, you have social workers, you have fire service officers, you have immigration officers. The idea is that, and when you come down to the level of the regional committee, the same structure is virtually replicated. You have the prisons, you have the police, you have the fire, all the security agencies that are well established and have presence across the length and breadth of the country. Now, the reason is that we don't have prisons in all the districts and municipalities of our country. So in places where, for instance, when you go to my constituency, the Bulsa North municipality, we don't have a prisons facility. The nearest prisons facility is Navrongo. But we have immigration presence in Sandema. So where appropriate, you may use police officers who would perform the role of supervision as if they were prison officers. That is why those committees have been carefully composed. So the fears raised by my brother are genuine, but they have been envisaged and addressed by way of the composition of the committees that we have. So the majority leader is right.
See, honorable members, this convicted person going to serve in the community is not going to be like the people are sentenced to prison, but occasionally they will take them out to go and work. There is a community service committee, and there is a community service officer appointed by the court. So those are the structures. When it is ready, they can convict people to go and serve in that community. So I don't think we have any fears. And I don't think we should even be giving them 5 years within which we should do that, or set a timeline for them. Because there is nothing in this law that's going to punish the minister if the minister couldn't deliver within the time frame. So why make a law asking somebody to mandatorily perform a particular act, and failure to perform that act will attract no punishment? What would have come out of the provision that you are making? So let's look at this. Else I'll put a question. Chairman of the committee, I want to put a question. On the proposed new clause 2, Those in favor say aye. Those against say no. The ayes have it. The new clause 2 is ordered to stand part of the bill. Now, clause 3. The new 3. Yes, move it. We are taking it one after the other. As captured in other paper.
Very well. So, as captured, it reads, the minister shall by the 31st day of March in each year submit to Parliament a written report on progress towards nationwide implementation, identifying the districts in which community service is available, the districts in which it is not yet available, and the steps being taken to achieve availability in those districts. I so move.
All members, it is for your consideration. Any further amendment? Yes. Majority, Chief Whip.
Speaker, I humbly of the view that this amendment should be abandoned. Should be abandoned because the regulation can clearly specify this. The regulation can provide these fine combs so that the manner of submitting the report to Parliament can be clarified. Now, if you see...
In other words, it is more of administrative function that should feature in the regulation rather than the act. Yes.
Sorry, in addition to what Chief Whip has said, if you look at that provision, assuming we get to a stage where the entire country is covered, we'll still be dealing with this provision where annually will be required to bring reports to indicate areas that are not covered and areas that are covered. And so we should leave it open, like he said, like an administrative issue, so that we don't even have to always be contending ourselves with a report being brought to Parliament to suggest which areas have been covered, which areas have not been covered.
Yes.
Speaker, I think the Chief Whip is in his element, so I'll take that advice and abandon it.
Very well, it's abandoned. Then we come to the 4, which in this case, if carried, shall become the 3.
Speaker, as captured on page 17, I take the proposed amendment on behalf of Afenyo Marking, where arrangements for community 42, so it now becomes 42.3, where arrangements for community service are not yet available in the district, a court sentencing a person in that district for a qualifying offense shall consider any available alternative non-custodial measure, including a suspended sentence, a fine with installment provisions, or a probation order before imposing a custodial sentence.
Have you looked at clause 48? Yes. Yes.
Speaker, I think it's in line, so we have to leave that because it's been captured by 48.
Yes.
Yes, so we abandon it.
Very well. Then the last one, if carried, shall become 3.
So, Speaker, with your permission again, an amendment proposed by Osaine Alexander Kwamina Afenyo Marking, and as captured on page 17 of the other paper today, and it's captured here as 5, but if it's admitted, it will become 42.3. If on the expiry of 5 years from the commencement of this act, community service programs. So let me finish, then we can deal with it. At least Yes, Speaker, I think that it's consequential because we abandoned the first one.
Very well.
We may have to abandon this one as well.
Very well.
Yes.
I'll now put a question to entire clause 42. Yes.
An amendment, amendment to clause 42.
Yes, you have
After subclause 2, add the following new subclause. The minister shall, on the advice of the Secretariat, not later than 2 years after the commencement of this act, and every 3 years thereafter, review the categories of offenses to which a community service order applies and submit a report with recommendations to Parliament for consideration and consequential amendment of this act.
How different is it from the amendment moved and abandoned?
The problem was where it was being proposed. It wasn't suitable because at the time, the focus, the responsibility was being given to the Secretariat. And then you guided that, you ruled that when that section does not deal with the mandate of the Secretariat, and therefore it will not be proper for it to be considered. But
it will feature when you look at the marginal note of 42.
So now the
Minister to notify Chief Justice of arrangement for community service.
So, and the head note was, a new rendition was proposed by my good friend.
It was not carried.
If it wasn't carried, then I'll make this proposal as a new clause, not as a sub-clause to 42. So my amendment will now be after 42.
Yes, what will be the head note?
Recommendations to Parliament. So the amendment proposed is that the minister shall, on the advice of the Secretariat, not later than 2 years after the commencement of this act, and every 3 years thereafter, review the categories of offenses to which a community service order applies and submit a report with recommendations
clearly
to Parliament.
The reason for not carrying that particular amendment was very clear. You agreed that Parliament cannot make law spelling out certain conditions for community sentencing. And then Parliament will again give power to the minister to go and review that when the legislative power by Article 93 rests with Parliament. So how can we sit that legislative power to the minister?
The full proposal takes care of your concern. And the full proposal here is that the minister shall, on the advice of the Secretariat, not later than 2 years after the commencement of this act, and every 3 years thereafter, review the categories of offenses to which a community service order applies and submit a report with recommendations to Parliament for consideration and consequential amendment of this act.
There is a procedure to follow when you are going to introduce a bill for amendment. So it cannot be by that way. The procedure for amendment, you know it. A bill must be introduced. The bill can either be a private member's bill or a bill introduced by the executives. Yes.
Speaker, let me urge my brother, Reverend Fojo, to abandon this at this stage.
I think we are just going back to resurrect what the House has already taken a decision on.
In fact, if I had heard him say that, and the minister may bring legislative proposals or amendment proposals to amend the law, then he would have been given some...
But are we supposed to legislate to tell the minister to bring a legislative proposal?
At all. So I think that let's abandon it. If you are really minded about this, when we get to the guidelines
for the regulation,
yes,
the regulation clause.
Yes, then we can maybe tidy it up, and then.
No, that cannot be because that regulation is going to be by legislative instrument.
Instrument, exactly.
And the legislative instrument will not go through the procedure
that the bill is going
the bill is going through.
And
one cardinal principle in a subsidiary legislation is that subsidiary legislation cannot amend the Parent Act.
At all.
It is the Parent Act that is stating the conditions.
Yes.
So you can, by subsidiary legislation, amend those conditions.
So, no.
No,
So let's
it
amend
cannot feature at all in the bill. It cannot feature in the bill. You would have been given part of your legislative power, which is exclusive under Article 93 to the minister. And it will not be proper. So we move to clause 43.
Social
Or did I put a
inquiry
question on the
report.
entire clause 42? Very well. Those in favor of clause 42 standing part of the bill say aye. Those against say no. Clause 42 is ordered to stand part of the bill. Now clause 43.
Social inquiry report.
43.
Yes, Chairman of the committee.
Amendment proposed, subclause 1, line 3, delete probation and insert community service. This is consequential, Mr. Speaker.
All members, this is consequential. I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Yes, still clause 43, VII.
Amendment proposed, subclause 2, line 1, delete probation and insert community service.
It's
Again,
also
this is
consequential. I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Yes, Chairman, VIII.
Mr. Speaker, this amendment stands in the name of the minority leader.
Very well.
Mr. Speaker, I rise to propose this amendment on behalf of Osahin Alexander Kwame Afenyomakin. We intend to add a new subclause 3. A social inquiry report shall, in addition to the matters required under subsection 1, address A, the attitude of the victim or the victim's family to the imposition of a community service order. B, the convicted person's existing communities, ties to the community and capacity for social reintegration. And C, any risk factors or vulnerability considerations relevant to the safety of the convicted persons or the community during the performance of community service.
Yes, the mover. What is the meaning of your amendment?
Mr. Speaker, it seeks to add a subclause indicating that there will be a social inquiry report which addresses the various categories that has been listed, Mr. Speaker.
The whole clause is saying that where a court determines that a community service order should be made under section 45, the court shall, before making the order, direct a community service officer to A, conduct a special inquiry into circumstances of the case. 2, character and antecedents of the convicted person. And 3, health status of the person. And B, report to the court the findings of the social inquiry in the prescribed form. And you are asking that we should add the following clauses to it to make 3, or no, we have to read 2 before. A community service officer shall conduct a social inquiry under subsection 1 in the prescribed form. Then after doing so in the prescribed form, then you are saying 3, a social inquiry report shall, in addition to the matters required under subsection 1, address A, the attitude of the victim or the victim's family to the imposition of the community service order, the attitude of the victim and the victim's family. That's what we are asking to be added. And then B, the convicted person's existing ties to the community and capacity for social reintegration. And C, any risk factor or vulnerability consideration relevant to the safety of the convicted person or the community. Yes, Majority Chief Whip.
Speaker, let me urge the available leader who is exercising the authority of the minority leader to move this amendment, to abandon them, because one, the provision is badly drafted. Badly drafted. That's one. Two, you are asking that we should gauge attitude. Okay. Okay, I withdraw. No, I withdrawn. So it has to be properly structured, number one. Then number two, as part of the requirements, you are requesting that the social inquiry report gauge attitude, which is nebulous. It's nebulous. They cannot gauge attitude of the victims, or you are also widening it to the families. So the three things that you are asking us to gauge, let's abandon. Yes.
Speaker, there will not be the need for us to belabor the point. We've abandoned him.
Very well. Then I'll put a question on clause 43. As many as are in favor of clause 43 standing part of the bill say aye. Those against say no. The ayes have it. Clause 43 is ordered to stand part of the bill. Clause 44.
Conditions for making a community service order.
Chairman, amendment I ask.
Amendment proposed, subclause 1, paragraph D. After person, delete is a habitual convicted person and insert has a previous conviction.
Honourable members, the proposed amendment is for the consideration of the House. Any further amendment?
Chairman, Mr. Speaker, apologies. If the chairman can justify I know that it's a neater provision, but can you explain even the insertion of has a previous conviction?
We are simply...
You see, you know that in practice, they will ask whether the person is previously known, meaning that has he ever been convicted? Now, if you said a habitual, I mean, how do you determine that? How many times will constitute being previously known? Is it 3 times? Is it 4 times? Is it 5 times? So the terminology in the court is whether the person is known.
Speaker, just trying to seek clarification. So if a person is a habitual convicted person, is it the same as a recidivist? So instead of a habitual convicted person, we rather use the word a recidivist. But you are looking at the number of times.
Yes.
Yes, I get that. But I don't know how we can.
So the terminology, what the court takes into consideration is whether or not you are known, meaning whether or not you are previously convicted.
Personal experience. Please hear me. Personal experience. I was lawyer for an accused person. Of course. And our case was bad. So we were convicted. They got to sentencing. So this came up. Apparently, in respect of our previous offense, we were made to sign a bond of good behavior.
Yes, it's a conviction.
Yes. But it constituted enough grievous grounds for the court to impose a much severer punishment by way of sentencing. So, indeed, if the court asks that, is it known? Is it known? Irrespective of how severe the previous infraction may be, the court will take much stricter view of the
Yes,
fact
but you see, at the point
Speaker,
that the court
finish.
will be asking.
So, Speaker, so I had to go take the trouble to say that yes, we are known, but in respect of the previous one, it was a very minor, infraction.
Definitely, they will ask
at
the point of sentencing.
Yeah, to mitigate the sentencing.
So if the prosecutor gets up to say that, oh, you are known severally, you've been convicted 5 times.
Yes.
That will influence the judge in coming out with the sentence.
Exactly.
If they say you are known,
yes,
but you are cautioned and discharged,
yes,
then that will also influence the number of years that the court will give.
Speaker,
so at that point, there is an explanation as to whether you have been to prison severally or you
or
are
not. Or not. But
so the
Speaker,
opportunity is there to explain this to the judge.
Speaker, the point I'm trying to make is that here is the case, the person has a lawyer. In a lot of the cases that travels before the district courts, the accused persons that are convicted and awaiting sentences don't have lawyers. And so once their history is announced before the judge, then it becomes a basis for imposing a severe sentence. So, but I cannot fault the House in trying to say that there must be, instead of a habitual offender, it should be a previous conviction.
Yes.
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 So the question that was directed at me is why we should substitute habitual convict with previous conviction. I think it's about having this whole thing aligned with the Criminal and Other Offences Act. The language of that act is some person with a previous conviction and not a habitual convict. So it's about aligning the language, that's all.
I'll put a question. As many as are in favor of the proposed amendment by the chairman of the committee, say aye. Those against, say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Still on clause 44X.
44, Mr. Speaker, stands in the name of the minority leader.
Yes.
Yeah, Mr. Speaker, I rise to move this amendment in the name of Osahin Alexander Kwamina Afinyomaki to also introduce subclause 1 to add the following paragraphs. H, where the convicted person was admitted to bail before conviction, the conduct of that person during the period of bail.
You should move the G as in X.
The G.
Page 18.
Sorry, yeah. Mr. Speaker, yes. G, whether the convicted person has demonstrated remorse or willingness to make reparation to the victim or the community.
Honourable members, the proposed amendment is for your consideration. Yes, Chairman of the committee.
Proposed has already been provided for.
In F.
In F. 44F. Whether the convicted person has made any form of reparation to the victim.
Have you seen it?
Mr. Speaker, yes.
Yes.
So we abandon this.
Very well. Accordingly abandoned. Yes, XII.
Mr. Speaker, I do make this amendment in the name of Osahin Alexander Afenyomakin to add another subclause H, where the convicted person was admitted to bail before conviction, the conduct of that person during the period of bail, including compliance with bail conditions imposed by the court. Thank you, Mr. Speaker.
Yes, it's for the consideration of the House.
Mr. Speaker,
Chairman of the committee.
This amendment, I think, is appropriate. So the conduct of the convict whilst he or she was admitted to bail even before conviction is relevant. So, Mr. Speaker, I think that on this occasion, we would recommend or support the amendment.
So what specific conduct do you contemplate?
So, Mr. Speaker, if you look at 44, we're looking at conditions for making a community service order. So, the convict, whilst on bail, I mean, it's important that you examine his or her conduct. If, for instance, the person jumped bail whilst on bail, it may be dangerous for such a person to be ordered to do community service. Because if he once jumped bail, how sure are you, Mr. Speaker, that if such a person is ordered to do community service, he or she will not abscond and put the surety into trouble?
So I'll put a question. As many as are in favor say aye. Those against say no. The proposed amendment is ordered to stand part of the bill. Still on 44, that is XII.
Amendment proposed, Mr. Speaker, after subclause 2, insert the following new clauses. Subclause 3, 4. I move accordingly.
Honourable members, the proposed amendment is for your consideration. Any further amendment? In the absence of any further amendment, I'll put a question. As many as are in favor of the proposed amendment say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Still on 44, XII.
Amendment proposed, subclause 4, paragraph A, subparagraph II, delete probation and insert community service. This is consequential, Mr. Speaker.
It is consequential. I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. XIV, standing in the name of Minority Leader.
Speaker, the advertised amendment XIV at page 19, clause 44. Speaker, after subclause 5, insert the following new subclause. Mr. Speaker, considering the length of the amendment, I rely on same without more. Mr. Speaker, I so move.
It is for the consideration of the House. Honourable members, any further amendment? Yes, Chairman of the committee.
Mr. Speaker, I support the proposed amendment save the 49, no, sorry. Safe to say that the C is already covered by clause 49(2)(e) of the bill. So we can consider the A, B, but delete C, given that 49(2)(e) covers same. Thank you, Mr. Speaker.
Yes, the proposer, that is the further amendment emanating from the chairman of the committee.
Speaker, I'm in agreement.
Very well. So, move your amendment properly and let me put a question. Move your further amendment and let me put a question.
Mr. Speaker, I move that the proposed amendment be further amended by deleting clause 6C. 44(7)C, given that the said clause of provision is already catered for or covered by.
All members, I'll put a question.
49(2)(e).
All those in favor, yes, Majority Leader.
Mr. Speaker, I hope I'm not lost. We are looking at XIV.
Yes.
Page 19, XIV.
Yes.
And what the minority leader is proposing is that if before conviction somebody is held up in detention, lawful detention, maybe the person was granted bail, but the person couldn't meet the bail terms. But was granted bail. That would be lawful custody or on remand. What you're saying is that the judge, in calculating community service, should sit down and be engaged in the mathematics of determining how many days were you held, how many days were you held, and then now calculate that because you were held for 30 days, if you're going to do community service for 60 hours, I am hereby reducing the community service by 24 hours and etc. I believe we will be imposing too much. I know. I believe we will be imposing too much.
Honourable Majority Leader.
Too much
in practice, some judges would ask, "How long have you been in custody?"
Yes. I know, Mr. Speaker. No, I'm not opposing because. No, I'm not opposing it because it is coming from you. You see, sometimes when we are doing these things, let's consider the implications generally on the levels of crime in the society. Already, by this, we are relieving you of a period that you ought to be in custody. No. We may be saving money, but by passing this law, we are already saving you from custodial sentencing. Now, if you further ask that we use all previous, custodial sentences, I mean, not custodial sentences, custodial incarceration, pre-trial, pre-conviction incarcerations, to further reduce. I'm just concerned about at the end of the day, what we'll be doing to the notion of punishment after you have committed an offense, will that not lead to crime becoming very rampant because people know that, well, if I commit this crime, I may end up just spending a few days of community service. So I support the community service, but every effort to further reduce it, I think, should be watched at this stage. I think as a country, let's proceed cautiously. Let's be more gradual in our approach than this attempt to almost erode the concept of punishment as a consequence of conviction. I think we should be careful. I think we should be careful.
Yes. Speaker, maybe for the first time, let me disagree with my leader. Now, leader, the danger...
Are you sure that is the first time?
I think so. Leader, I think the danger is that we are already faced with circumstances where officers of the law abuse citizens on grounds of suspicion. So you are arrested based on some complaints, you are placed in custody, they look at the 48-hour mark, they rush to court, they get the court to impose a remand, and then they bring you back. Now, what you want to avoid is that where the charge is in respect of any of the offenses that this law will specify, then please imposition of custody or pre-investigation or in the course of investigation custody should be as much as possible avoided. Otherwise, then, when the matter is determined expressly or summarily, and a community service is by way of sentences is imposed, then it would have been unfair to you if you were held in custody for some number of days. So I see where the minority leader is coming from and want to cure. So we can, maybe in the course of the belly of the law, we can say that where the charge is in respect of any of the offenses prescribed by this act, then the police themselves, it's implied that the police themselves may not impose a custodial in the course of investigation custody. We can provide a guide by that. I don't know what the chairman thinks, but I see the danger in that, yes. They can abuse it.
Yes, the proposer. Do you have anything to say? Yes, Chairman.
Oh, Mr. Speaker, I want to reiterate my earlier position on the matter by stating that I have personally stood in as counsel for accused persons who were subsequently convicted. And the courts on those occasions actually took into consideration the period the convict, stayed in remand. And in this particular case, I don't want to be very specific because of confidentiality reasons. The person in question had actually been on remand for close to 3 months. Close to 3 months. So the judge in passing sentence took that into account and sentenced him to 2 months. He had said originally that he was going to sentence the convict to 6 months. But in the meantime, when his attention was drawn to the fact that the convict had already spent 3 months on remand, he gave him only 2. Well, it was 4, but he started computing time from the time the person went on remand. So I think, given this particular position and experiences that I have gone through as counsel, the amendment is appropriate.
Mr. Speaker, my major concern is 7B. 7B of his proposal, the reduction in community service hours shall be calculated on the basis that 1 day of remand custody is equivalent to 8 hours of community service, subject to the minimum period prescribed under Section 53A. So all of us who have practiced know that the courts always take into consideration how long you were held in detention when they are determining, their custodial sentence.
But to say,
but for you to now say that he must sit and calculate this 1 day amounts to 8 hours. On what basis have you come to a conclusion that we should legislate that 1 day amounts to 8 hours of work? Is that calculation that so you leave it within the discretion of the judge?
Yes.
Like we've always known in custodial sentencing. In custodial sentencing, it has always been within the discretion of the judge. But you are now tying the judge to sit and be doing mathematical calculations that since he was held for 1 day, then 1 day amounts to 8 hours of community service. Like, that's my issue. Leave it within the discretion of a judge. So leave out the B. Leave out the B.
Mr. Speaker, just to draw my leader's attention to clause 53, yes, which reads as follows. The community service order shall be for a period of A, not less than 4 hours, and not more than 8 hours in a day, and B, not more than 6 months. So, Mr. Speaker, this provision gives us an idea of how to compete.
No, but you see,
Of
in a court,
the service,
you ask the person how long he has been in custody, and that goes a long way to influence the judge in exercising his discretion. But to tell the judge that if the person is in custody for 30 days, he should calculate 8 hours a day plus that is what the majority leader is raising. Yes.
Mr. Speaker, first and foremost, I believe that the essence of this probation, this business of non-custodial sentence, is to lessen the burden, one, on government and the occupancies in our prisons. And then also the community service is to make sure that we can get some benefit from this business. Mr. Speaker, as we speak today, even in Norway, there's nobody in prison, basically. So I believe that the argument majority leader is making, it's not something that we should take on board, because if we give so much discretion to the judges, I believe that then we are not creating certainty in the law or in the minds of Ghanaians. Because if 8 hours is the maximum you can get for a community service, that should be used as a basis for 1 day for custodial sentence. Because you cannot say 4 hours. If he says 4 hours, then we'll be cheating the system. But if it's 8 hours, then we are sure that for every 1 day that the person actually spends in prison is 8 hours of community service. Then I think that is fair. And it brings some certainty also to the judgments that our judges will be issued.
You see, practically, some persons are remanded in police custody. Some goes to prison custody. So the judge takes all these factors into consideration. You can be in police custody for 6 months, and it will be treated as if the judge will say, instead of convicting you for 3 years community service, I'll give you 2 years. You can be in prison custody, knowing the difference between prison custody and police custody, for 3 months. The judge can equate that 3 months to 1 year, knowing that the conditions are not one and the same. You understand? But when we are asking the judge that treat 1 day as 8 hours, is it 1 day in police custody or 1 day in prison custody?
But, Mr. Speaker, both of them, you are still serving the government. It's still custody. You are still serving the government. It's still custody.
Well, I'll put a question. Yes.
Speaker, first of all, that particular provision is making reference to the 53A. 53A has defined the basis of this amendment containing B. That's why we say subject to 53A. 53A says community service shall be for a period of A, not less than 4 hours and no more than 8 hours in a day, and not more than 6 months. Now, the essence of this law is to do away with post-conviction custodial sentencing. Is to do away, if you are providing an alternative, we are doing away with the status quo. Now, situations where pre-conviction custody is on record and you are now going to impose a non-custodial sentencing on the convicts, the computation must factor what has already been provided for in law. And the 53A has given us in real time what a community service day of quote-unquote imprisonment means, that it shouldn't be more than 8 hours. Now, Mr. Speaker,
It will be unfair to
if you come back to what my respected colleague was trying to say about judges having to calculate, Mr. Speaker, in our court, don't our judges calculate penalty units? When we talk about penalty units, it's equivalent in monetary terms. It's determined. So it is not about the judges being burdened or that their hands being tied. His argument is that we should allow them discretion. And he seeks to dismiss the elaborate provision provided thereto in this amendment. But that is not coming from the proposer. The proposer of the amendment is making reference to what is already provided for in the law. Mr. Speaker, I believe
Yes, Honorable Baba Jaman.
Mr. Speaker, in trying to make laws, we shouldn't create a situation where we rather go and even create difficulty in the implementation of the law. This calculation that we are, your B, A, I agree, because it's, hold on, the A, I agree. A is already in practice. Most judges, in fact, almost every judge will consider how long you have been in custody before he gives sentence. But to go into calculation, Mr. Speaker, it will be a source of even litigation in the courtroom, confusion between the judge and the lawyers on the ground. Mr. Speaker, we have accepted the amendment that whatever time you are spending in custody should be considered. Why this calculation? Are we now going to sit down? If we are not careful, by the end of the calculation, we will have more, the state will owe the convict. By the end of calculation, the state will owe the convict. If the person has been kept in custody for maybe 1 year, and then he's sentenced 3 years, 1 day, 8 hours, calculate and see. We'll be owing him. Leave it to the discretion of the judge. He should take into consideration. I think that is the best way. If the B is out, we will have a good bill and go ahead.
You let me. Mr. Speaker.
Yes.
If you look at the law we passed, the law we are passing, and clauses that we have already accepted, power to make community service order. My understanding is that we said where a court is satisfied that the conditions for making a community service order have been met, that court may make a community service order directing the convicted person to perform a community service. So even community service itself is still a discretionary matter because the court may make it if you have met the conditions. Now, take the clause you are asking to be inserted after clause 5. The clause you are asking to be inserted after clause 5 says that in determining the duration of a community service order, the court shall take into account any period during which the convicted person was held in lawful custody on remand in connection with the offenses for which the community service order is made. And I'm saying that traditionally, it has always been expressed in discretionary terms, that the court may take into consideration the pre-conviction custody. It has always been the case that the court may, but you are saying that the court shall mandatorily. Then you now go and fetter the powers of the court by even calculating the days for them relative to the hours. So first you take away their discretion, which has always been the traditional position, that you may consider the previous stay of the person in custody. But here you are saying shall. That means that the court has no discretion in the matter. Then you now come and say that, and even after you have taken away the discretion, you are calculating the specific days. So if they spend 30 days, you must deduct 8 hours out of it per day for them. So that ties the judge too much. So I plead with you. Yes, so in the case of 6, I agree with you that the court may take into account any period during which the convicted person was held in lawful custody. Good. Then 7, for the purpose of subsection 6, which is more of an interpretation clause, for the purpose of subsection 6, period in lawful custody on remand means any continuous period during which the convicted person was detained pursuant to a warrant of committal or a refusal of bail by a court of competent jurisdiction pending trial or sentencing for the offense charged. That, I think, can stay. My issue is with B, where you are calculating, it said the reduction in community service hours shall be calculated on the basis that 1 day of remand custody is equivalent to 8 hours of community service subject to the minimum period prescribed under section 53A. So that one should go, and then should. Yeah, so that's one. So I'm making the further amendment. So in place of shall, let's say may, and then we delete B. And then the rest can stand. Yeah.
Yes, Majority Chief Whip.
Speaker, indeed, let me support the present proposed amendment by the leader. Speaker, because again, from a personal experience, we did a trial, was a criminal matter, robbery. So after about 4 years, my client remained in custody for the entire 4 years. And during sentencing, I put in a plea of allocutus. That's a plea of mitigation and all that. The judge said, yes, counsel, I've heard you. But given the nature and character of the evidence led and recanted, I am minded to impose the sentence that the court sees fit. So it means that even though you may legislate, that is why it must be discretionary. The court may do so, given the peculiar circumstances of the case. If the peculiar circumstances of the case said that they may not have regard to the period spent in pre-conviction custody, the court may be minded not to do so. So I support the present amendment by leader.
I can see the sense of the House. What I intend to do is to put the question one after the other. So the first question is put on the proposed amendment as in the new clause 44(6). Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now we come to 7. 7 is in A, B, C. I will then put the question first on A. Very well. So I'll put a question on A. Those in favor of 7A, standing part of the bill as amended, say aye. Those against say no. The ayes have it. The 7A is ordered to stand part of the bill. Now 7B. I'll put a question. Those in favor of 7B standing part of the bill say aye. Those against say no. I'll put a question again. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now C is abandoned. Then I'll put a question on the entire clause 44 as variously amended. Those in favor say aye. Those against say no. All members, the ayes have it. Clause 44 is ordered to stand part of the bill. New clause as in XV. Yes.
Speaker, thank you very much. Speaker, I move this, which is captured on page 20 of today's order paper, on behalf of Hussein Alexander Kwamina.
He's here.
Speaker, but you can be here.
If the proposal of the motion is here,
Speaker,
how will we be acting on his behalf?
Speaker, there is a power of attorney on this matter. Speaker, you see, you are compelling.
Once he's here, you are Fantus official.
Speaker, the amendment proposes after clause 45, add the following new clause. Sentencing guidelines. Speaker, this is 4 sub-clauses, so I'm not too sure if I would have to read or I would want them adopted. I so move.
The proposed amendment is for the consideration of the House. Yes, Chairman of the committee.
Mr. Speaker, the proposed amendment is quite problematic in the sense that sentencing guidelines are born out of administrative directives. So, given that they are born out of administrative directives, and mostly they are made by the Chief Justice, yet we are seeking to legislate on such guidelines. I think that, Mr. Speaker, we may be making incursions into the Chief Justice's domain. Currently, we have sentencing guidelines. And those guidelines are not the product of any legislation. They are administrative in character. So I would urge that we leave this domain to the judiciary. I mean, the Chief Justice, after the passage of this bill, can formulate guidelines to at least regulate the conduct of judges when they have tried cases and convicted accused persons what rules should guide them in passing sentence. And so, Mr. Speaker, that is the position I would take in relation to this proposed amendment. Secondly, Mr. Speaker, the amendment makes reference to guidelines as though we have them captured in a schedule to this particular bill. We don't have same. So I believe strongly that once we don't even have the proposed guidelines captured in a schedule, we should abandon this particular amendment.
Honourable members, is for the consideration of the House. Yes, majority that. It was assumed you are not here and somebody acted with your authority. That's correct. And you still want to have the floor. Once you are here, he is Fantus official. You have the floor. You have the floor.
Yeah, so, Speaker, yes. I want to, with your leave, further amend the clause 2 by deleting. By the clause 1, Mr. Speaker, clause 1. Clause 1. So, Mr. Speaker, on the issue raised in opposition in respect of practice directions, Mr. Speaker, it is always better to legislate rather than leave certain matters open for administrative directions. Speaker, if I may recall what the Supreme Court said in the Benjamin E. Mensah case, the Supreme Court was very unequivocal, speaking through my Lord Atukuba. The Electoral Commission was found wanting on the matter of a constitutional instrument to regulate the 2015 Assembly election. And when the court inquired, the Electoral Commission said it relied on some administrative directions. And the court said no. Once the Constitution provides for a CI to regulate every public election, you cannot circumvent the law by telling the court that on that very occasion there was no such CI and that the commission was relying on some administrative guidelines to conduct a public election. Accordingly, the whole notice given to the public was struck down and the election postponed to allow for the EC to now lay before Parliament a new constitutional instrument. It is therefore proper, fortified by this position by the court, to say that if Parliament has the opportunity to legislate to avoid ambiguities, we must do so. It is the reason why, Mr. Speaker, even when we legislate, we allow for an EI or an LI for further regulation to operationalize the law where we think that there may be some other areas. So the issue of administrative guidelines which guidelines are clearly outside of the law, being used, Mr. Speaker, to perform an administrative function, the Supreme Court has already frowned on that. Otherwise, Benjamin Eyimensa's prayer would not have been held. He was a mere fisherman. So, I think that what the respected gentleman who spoke before me said, that indeed we need to rely on administrative directive to achieve this purpose. I'm just drawing this gentleman's attention. I mean, Honorable James Agaga is my my senior at the bar. I so much respect him. In practice, back in the days, criminal trial practice was part of his practice. We learn a lot at his feet. Mr. Speaker, he would have to yield to this position of the Supreme Court. That where the law provides for a certain procedure to be followed, you can only be on that path and that path only. You cannot now say you are using an administrative guidelines. It is the reason why the notice, Benjamin Eyimensa with respect, Benjamin Eyimensa, the notice, very well, that's another authority. I am talking about Benjamin Eyimensa. Very well, Mr. Speaker, I'm humbled in all humility. Yes, I was young, but Mr. Speaker, by the grace of God, I tried my best at the bar, and my prayer was upheld for and on behalf of my client. Mr. Speaker, that is the guiding law. So, Mr. Speaker, I would want the chairman of the committee, the Defense and Interior Committee, to have a critical look at the grounds of his opposition again. I am ready to take away the clause 1, which has to do with the schedule, because I noticed that the schedule I wanted attached is still not ready, it's not been advertised. So I'm ready to yield to you on that. I'm ready to yield to you, Honorable Agaga, on the 1, to delete it. But for the subsequent ones, I believe that we need the 2, which is the new one. We need the 3, which now becomes 2. And the final one would read what I've put there. The Chief Justice may issue practice directions for the uniform application of the guidelines. So that has also been cured. No, we already have the guidelines. Yes. So, Mr. Speaker, I think there should be no problem at all once I am amending the 1 to cater for his concerns.
Yes, Chairman, yes, Majority Leader.
Speaker, I'm trying to understand the basis of this new clause. Sentencing guidelines. And I was going to draw attention to the absence of any sentencing guidelines in a second schedule to the Act. Once you don't have that, how does 2 sustain itself? You don't have 1. How do you sustain 2? Yes, because it will be difficult to sustain 2 and then all the others. Okay.
Speaker, with respect, I think upon further consultation, we'll flag it and then try and clean it up and come back. The Speaker, that's the consensus.
I will flag it by coming back. You should try and convince the House that administrative guidelines should be a subject matter of an Act of Parliament. Because it's going to be, coming here as an act. It's not coming under regulations or nothing.
Well, Mr. Speaker, because you've spoken for the records, that is not my intention to make an administrative guideline take precedence over law. Is that
No, it's now going to be a subject matter of an act of parliament.
Well, Mr. Speaker,
It remains a guideline administratively.
We move to clause 45. Power to make community service order.
Yes, Chairman of the committee.
Amendment proposed, subclause 1, line 3, after order, insert as set out in the first schedule. I move.
The proposed amendment is for the consideration of the House. Any further amendment? In the absence of any further amendment, I'll put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Clause 40 is, let me put a question on entire clause 45 in the absence of any further amendment. Those in favor of clause 45 as amended standing part of the bill say aye. Those against say no. The ayes have it. Clause 45 is ordered to stand part of the bill. Clause 46.
Nature and type of community service.
Chairman of the committee.
Amendment proposed, subclause 1, line 1, delete probation and insert community service. Consequential amendment, Mr. Speaker.
Yes, this is consequential. I'll put I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 46 is ordered to stand. The proposed amendment to clause 46 is ordered to stand part of the bill. Now I'll put a question on entire clause 46 in the absence of any further amendment. Those in favor say aye. Yeah, very well, very well, very well. Let's go to amendment numbered XVIII, standing in the name of Osahin Alexander Kwamina Aponyomakin.
Speaker, I have the permission of Osahin to move this amendment on his behalf. Speaker, if I have your permission as well, your leave.
But it is only fair that in the absence of the person, you can be authorized to perform an act on behalf of him.
Speaker, you know all of this is part of the learning process. So,
please.
Yes.
Thank you very much. The rules are relaxed, so.
Yes, Speaker, like you educated me earlier, looking at page 20, Speaker, we are taking this from page 20, and from today's other paper, Speaker, the amendment proposed is as follows. After subclause 2, insert the following new subclauses.
As captured in page 20 and 21.
As captured in page 20 and 21.
Of today's other paper.
Yes, yes, Speaker.
Yes, the proposed amendment is for the consideration of the House. Yes, Chairman of the committee.
Mr. Speaker, it's difficult to understand or comprehend which form of community service is demeaning or degrading. Community service is community service. Once you suffer a conviction and the sentence does not exceed 3 years, Mr. Speaker, a judge can, in the alternative, sentence you to community service.
You have to legislate. You have to legislate things that can be determined so that it is enforceable. If you say that a court shall not assign a convicted person to perform a nature or type of community service that is demeaning, degrading, or likely to expose the convicted person to public humiliation beyond what is necessary, how do you determine what level of public humiliation is necessary? How do you determine that? beyond what is necessary for the purpose of accountability and rehabilitation. This is going to be difficult to enforce. It's going to be difficult to determine, very subjective. What may be demeaning to Mr. A may not be demeaning to Mr. B. Your perception of what constitutes humiliation may be different. So I plead with you. I'm sure the judges subconsciously take on board all these considerations when they are determining what you should do. But to indicate it as a specific provision in the Act, what will happen? Somebody will start challenging the court. And then it becomes impossible for the courts to implement what we have designed for them.
Speaker, I've had a very beautiful conversation with the venerable clerk, and I had given him some examples of situations where the community service can be very demeaning, degrading, and what have you. But I do not want to go into details because some of them are not too good for this house to capture. But it's true. Save that the majority leader's final comment nails the conversation better. That to the extent, if you are not careful, there will be a Pandora box. Everybody, you now make applications trying to understand what is demeaning, and obviously, Speaker, flowing from that, I think that we would rather want to abandon this one and proceed on the next one. Thank you.
Very well. The proposed amendment accordingly abandoned. Then I will put a question on entire clause 46 as variously amended. Those in favor say aye. Those against say no. The ayes have it. Clause 46 is ordered to stand part of the bill. Now, there is a new proposed clause after clause 46 standing in the name of the minority leader. You have the floor.
Speaker, that is also captured on page 20 of today's order paper, and it reads, which is 46.4. In determining the nature and type of community service, a court shall, where practicable, have regard to any skill, qualification, or experience of the convicted person that may benefit the community. And I so move. And this one, I think.
But this is not different from XVII. See, Honorable Jerry Ahmed, the whole thing is punishment. So you prefer to be sentenced to prison and be asked to go and do the community work and go back to the prison. Because these days, I see prisoners being brought out to do some work. But in this case, you are not in the prison. You are outside doing this work. And we want to tie it down with some qualifications. Then it means that you can enforce the law. Because if you ask me to go and weed the side of the motorway, and I say it is degrading, I'm not going to do it. It must go back to court for the court to determine whether that work that you ask me to do as a convicted person is degrading or is not degrading. Because that's how the determination can be made. Yes?
Being a non-lawyer, and sometimes I feel that it was good I didn't go to law school. Reading some of these amendments, it sounds to me like we are making this community service thing for some upper class special people.
Having lived in a community where there's community service, what do you mean by they shouldn't give them a sentence that is demeaning? The crime that they committed, wasn't it demeaning? But if you look at this, you are asking the court, a court shall not assign. Why would you put restrictions on the court? Okay, let me read it for you, sir. Osahine. A court shall not assign, and a probation officer or a supervising officer shall not direct a convicted person to perform community service that is degrading. Isn't that what we are talking about? Look, then have a human rights act somewhere. Community service. Who is being sentenced to a community service? Honorable Mr. Speaker, this before it even gets to the chairman, let's abandon it.
Honourable members, let's take into consideration that though we have our respective rights, the Constitution is clear that based on certain circumstances, that your right can be taken away from you. So you cannot be a convicted person. They ask you to go and weed on the motorway. Then you say that weeding on the motorway is demeaning because there are a lot of cars passing.
Speaker, context matters. It is not the convict who is demanding. It is the law that is upholding the dignity of that convict. That is the whole essence of this provision. That is the whole essence of this provision. Don't we hear of complaints about how probation officers or prison officers sometimes act in excess of their mandate? This is basically to cure possible excesses in the discharge of the mandate.
So who determines whether the work is degrading or humiliating?
Mr. Speaker, with respect, quite rhetorically, I humbly hold this view from the rhetoric question you posed. If the honorable member had read it in full, if we say, Mr. Speaker, that to perform community service is that this degrading or humiliating, Mr. Speaker, to say something is humiliating or degrading, hazardous and unsafe, having regard to the convict's health status. C, disproportionate to the convict's fiscal capacity. Discriminatory or any ground prohibited by the Constitution. Mr. Speaker?
Yeah, I ask because you said it is not the convicted person that is demanding.
The law is saying
and
so.
It is the convicted person
who is the
being
beneficiary
asked
of
to work.
No.
That will have to say that the work that you are giving me to do is humiliating. It is degrading.
Mr. Speaker, not so. Respect. Mr. Speaker, that is not the case. That is not the case. It is not the convict. We are legislating to guide the one supervisor. Mr. Speaker, let's go to the Constitution. Let's go to the Constitution. Article 296.
Article talks about discretionary powers.
Indeed, Mr. Speaker.
Yes.
Indeed.
Yes.
Indeed. Mr. Speaker, 296, for the avoidance of doubt, where in this Constitution or any other law discretionary power is vested in any person or authority, A, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. And, Mr. Speaker, the C is not very relevant, but for this purpose, let me add. And where the person or authority is not a judge or other judicial officer, there shall be published by the constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this constitution or that other law to govern the exercise of the discretionary power.
Yes,
Mr. Speaker,
with the provisions that you have read.
Mr. Speaker, may I finish?
Yes, finish.
Not
you are caught by your own provision, but finish.
Yeah, Mr. Speaker, not budgeting now. Mr. Speaker, if you look at the provisions, what the proposal, it is all aimed at giving effect to 296. When the law is saying that the nature of community service should not be aimed at degrading or humiliating, what the law then is saying is that probation officer, supervising officer, be guided by Article 296. Somebody may say that, okay, I know that you were a politician. Now you've been convicted. I know that your children attend this school. So go and carry this wood where your children have just closed, just to humiliate. Mr. Speaker, that is please. We are legislating for tomorrow. Let's be careful, because in this country, you and I know the extent to which some law enforcement officers can go. In fact, it is the excesses of the law that is giving rise to this community service bill. It's how sentencing regime has caused escalation or dehumanizing of convicts. Issues have been escalated because of the nature of sentencing. People's lives have rather been destroyed rather than being reformed. It's the reason why there's this new sentencing regime by our courts. And for the first time, this parliament is giving effect to that policy by doing this enactment. So we must be mindful. The prison officers, they are not perfect, but at least the law must guide them so that anytime they are crossing the red line, someone can take them on. Human rights activists can come in, intervene. Are we saying that a person convicted has his human right taken away from him because of conviction? No. The person has a right to his dignity.
Honorable Minority Leader, with all due respect, because of your conviction, you have a right to move, but you are confined in prison. Is your right not taken away from you?
Mr. Speaker, I shouldn't be taken out of context. What I am saying is that even when your rights by law, your right to free movement is taken away from you, that impairment must be subjected to your right to personal dignity. That is a fact. The dignity of a man, a Ghanaian, is guaranteed by the Constitution. So even where, Mr. Speaker, even where the rights, certain rights of the citizen is being taken away, there are some that are guaranteed. So for instance, you are convicted. It doesn't mean that you can be denied your food. You are supposed to be fed. The fact that you have been convicted doesn't mean that you will be denied.
Minority Leader, will you agree with me that today, the laws as it stands, your life can even be taken away based on conviction?
Mr. Speaker, right must be defined. Some right can be taken away.
I'm saying that your life You
By
can
law.
be sentenced to death by law.
Mr. Speaker, by law.
Yes.
But even so,
So if you make a blanket statement, it will not gel well within the law. Now, Section 296 that you have mentioned, the other part is subjecting it to statutory, Article 296. Article is subjecting it to statutory instrument and constitutional instrument. However, this is not a statutory instrument. This is an act of parliament. So in making an act of parliament, we need to be very careful legislating on certain things.
Speaker, the head note.
Yes.
I titled it Human Dignity.
Yes.
Mr. Speaker, human dignity
Yes.
and protection of convicted persons.
Yes.
Mr. Speaker, I am very clear on the proposal before the House. I said human dignity. I am mindful of the situation of that person, that for the time being, certain rights have been taken away from him by law. But in so doing, his dignity as provided for by the Constitution. Mr. Speaker, the chapter 5 of the Constitution, I believe, deals with human rights.
If the community service is for you to go and sweep market, and you don't want to sweep market, you don't commit the offense.
Mr. Speaker,
Leader, let me hear Roxanne Dapamoko.
Mr. Speaker.
Roxanne Dapamoko, let me hear him, then I'll come to you, leader. He's been on his feet for some time.
Speaker, I've been trying to catch your attention. Speaker, the minority leader in reacting to the Honorable Samantha Mills actually said that he hasn't read the law. I thought that. Yes, he said he hasn't read the bill in full. And but it looks, yeah, so it didn't come across well. So please, if that can be, yes.
Mr. Speaker, respectfully, I mean, it's only fair. The point I was making was that the member had not appreciated in full the provisions contained in the proposed amendment. However, if it came across as being disrespectful to him, I withdraw that, Mr. Speaker. It's only fair. It's only fair.
Yes, Majority Leader.
Yeah, Mr. Speaker, I can perfectly understand the basis of this proposed amendment. Article 15 of our Constitution says that the dignity of all persons shall be inviolable. So whether held in custody or not held in custody, whether you are a convict or you are not a convict, the dignity of each and every one of us is inviolable, and our integrity is protected by Article 15 of the Constitution. Then it goes further to say, no person shall, whether or not he is arrested, restricted, or detained, be subjected to torture or other cruel, inhuman, or degrading treatment or punishment. So I think that this is what you are trying to legislate. But my caution is that it is already enshrined in our Constitution that you cannot, dehumanize, degrade, and torture or be cruel to any human being. It is captured in our Constitution. We have signed on to the international human rights treaties, and it is captured in the various international human rights treaties. So I think that the courts have always, taken that into consideration, and the judges in determining community service will always take that into consideration. I think that if anything at all, you may just want to reframe Article 15 and capture it. Just reframe Article 15, and capture it, because that's basically what you are trying to do. It's already a constitutional provision, so that makes it easy for all of us.
Speaker, in my early days as a minority leader, I had some veritable words to describe the majority leader. Because I'm unsure of what he may likely do tomorrow when he reads the business statement, I'm not going to commend him for this industry. But clearly, you know that when there's no mischief in him, he does good business. And when he decides to help, he helps. So, Mr. Speaker, is the majority leader paying attention to this provocation? Yes, but I want him to hear this provocation. Mr. Speaker, he's brought a very beautiful suggestion. It's good. So my own view is that the draft person would have to coin it, take the Article 15, and as the lawyers will say, for the appropriate legal fees, mutatis mutandis. Yes. Mr. Speaker, yes. I want people to consult for the meaning of mutatis mutandis. On this occasion, the firm will take a legal fee just for using the Latin in language. Mr. Speaker, so if the draft person can factor that position of the majority leader and deal with it as a new subclause after 46. And in that sense, I would abandon the entire rendition and allow the draft person to figure out the right to personal dignity as provided for in Article 15 in place of what I earlier proposed. Accordingly, the advertised amendment is withdrawn, Mr. Speaker.
Very well, the advertised amendment is withdrawn. I urge the drafters to cross-reference Article 15 of the Constitution accordingly and appropriately. I will then put a question on entire clause 46. Those in favor say aye. Those against say no. The ayes have it. Clause 46 as variously amended is ordered to stand part of the bill. Clause 47.
Concurrent community service orders.
Chairman of the committee.
Mr. Speaker.
Clause 47.
Yes, there is yet another amendment. Still
there is
on
no
clause,
advertised amendment
on clause 46.
Where is the advertised amendment?
So, community service for child offenders. It stands in the name of the minority leader. No, we haven't dealt with that one.
Very well.
Speaker, page 21 of today's order paper. Speaker, I am moving this amendment on behalf of Proceedings Alexander Kwamina Afenyomarkin. Speaker, the amendment proposed is as follows. After clause 46, add the following new clauses. Human dignity and protection of convicted persons. Speaker, I rely on the following.
Chairman of the committee.
Mr. Speaker, legislation on that subject, Mr. Speaker, I would urge that we refrain from seeking to legislate in a community service bill, which is a completely different subject area, and allow the said Juvenile Justice Act to be the act to deal with issues bordering on juvenile justice. That law is so, expansive. It contains provisions on how to deal with juveniles and all that.
Yes. Honorable Jerry Ahmed.
Because if all of those, like he rightly stated, have been captured.
You know that juveniles, upon conviction, they are not sent to our regular prisons.
Yes, yes.
Their treatment is different.
Very much so, Speaker.
But this is a general community service sentence. And what would you want to subject the juveniles to?
Speaker, that is why per his submission, I am asking that we should abandon. We shouldn't be labor. Especially if all of those have been captured in another law.
Very well. So having abandoned it, the question that I put on clause 46 still stands. The ayes have it, and clause 46 is ordered to stand part of the bill. Clause 47.
Concurrent community service orders.
Chairman of the committee.
Mr. Speaker, we don't have any advertised amendments.
It is for the consideration of the House. Honourable members, any proposed amendment to clause 47? In the absence of any proposed amendment, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. Clause 47 is ordered to stand part of the bill. Clause 48.
Suspended sentence in default of community service.
Chairman of the committee.
Amendment proposed, delete and insert the following. Suspended sentence in default of community service, where a convicted person in respect of whom a court has made a community service order is unable for good cause to comply with the order, the court shall suspend the community service for a period that the court determines.
Honourable members, the proposed amendment is for your consideration. Any further amendment? I'll put a question on the chairman's amendment. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Yes, still clause 48. Amendment number XXI, standing in the name of the minority leader.
Speaker, SSI, as captured on page 22 of today's order paper, Speaker, amendment proposed, delete and insert the following. Suspended sentence in default of community service, running down to 5, subclause 5, Speaker. So move.
It is for the consideration of the House. Honourable members. Yes, Chairman of the committee.
Mr. Speaker, clause 53 of the bill covers the amendment in question. And so I should think that the amendment ought to be abandoned.
Speaker, I've seen 53, which actually has a different rendition but same meaning. Consequences for breach of community service order. Just trying to juxtapose that with this. Speaker, if we can just defer a bit, just maybe for a few minutes, whilst I try to, so that if there is something which is not captured in 53 and we can bring it on board, so that we have a comprehensive nature of the consequences, that would be good for me.
So what is your request?
Just asking that it should be deferred for me to compare the two, whilst we go on another one.
Very well.
Yes, yes.
We then move to clause 49.
Register of community service orders.
So clause 48, the proposed amendment by minority leader deferred. Yes, 49, Chairman of the committee.
Amendment proposed, subclause 1, line 1, delete probation and insert community service.
It's consequential. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is carried. I will put a question on entire clause 49 as amended. Those in favor say aye. Those against say no. The ayes have it. Clause 49 is ordered to stand part of the bill. Yes, a proposed new clause in SXII, standing in the name of the minority leader.
Speaker, is it SSIII?
Aye.
The ayes are 3?
Yes.
Very well. Speaker, as captured on page 23 of today's order paper, I move the amendment proposed by the minority leader to include, after clause 49, add the following new clause: protection and personal information. And Speaker, as captured on the other paper, all of that I rely on.
Well, it is for the consideration of the House.
My Lord, sorry, Mr. Speaker.
Yes.
Mr. Speaker, I have the premonition that one day you become a Supreme Court judge. Maybe that is why.
That is what Habib has been saying.
I described you as my Lord.
That's what Habib has been saying.
Yes. So I have the intuition. Mr. Speaker, the amendment, I think, is in line with the Data Protection Act. And therefore, barring any objections, I think the proposed amendment is appropriate.
Very well, I'll put a question. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. I'll put a question on entire clause 49. Those in favor say aye. Those against say no. The ayes have it. Clause 49 is ordered to stand part of the bill. Clause 50.
Enforcement of community service order.
Yes, Chairman of the committee.
Amendment proposed. Subclause 4, lines 1 and 3. Delete probation and insert community service.
It is consequential. Those in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Yes, Chairman of the committee, SXV.
Amendment proposed. Subclause 5, lines 1. Delete probation and insert community service.
It is consequential. Those in favor say aye. Those against say no. The ayes have it. The consequential amendment is ordered to stand part of the bill. Yes, Chairman of the committee, SXVI.
Amendment proposed. Subclause 6, lines 3. Delete probation and insert community service.
It is also consequential. I'll put a question. Those in favor say aye.
A number of consequential amendments running up to clause 57, and there are quite some substantial amendments, I would say, to structure work. If we can take all consequential amendments, okay, all consequential amendments up to 57, and leave and defer the three substantive amendments proposed by the minority leader, so that tomorrow we'll continue from there.
Yes. So we then come to the proposed amendment numbered XXIX. That's clause 52.
Yeah, Mr. Speaker.
So we defer 51.
Yes. Mr. Speaker, the
Because we
proposal
already
is that,
defer 48.
That's so. That is so. Mr. Speaker, the proposal is that those consequential amendments up to 57, he puts them together. Then we can debate it. Because they are consequential. So we are deferring them. So,
Have you read the case of Azwame versus Attorney General?
Mr. Speaker, please repeat yourself.
Azwame versus Attorney General.
Well, Mr. Speaker, you may guide us.
Where section 48 of the Narcotic Control Commission has been struck out because it has not been debated on the floor of Parliament.
But Mr. Speaker, I'm not saying we shouldn't debate it. I'm saying that the amendment must be.
These are consequential amendments,
yes,
but by the guidance of the Supreme Court, in that decision, we have to take it one after the other. Because we have to put a question on a specific clause, one by one.
Interpretation being given to the ruling, though.
So, Mr. Speaker, rather it is from 51. There's a consequential amendment in 51, and then his amendment in 51, that's what we would defer. Then there's a consequential amendment in 52. Then in 53, 54, 55, 56, 57, 57.
As for the consequential amendments, Leader, it doesn't take time.
Yes.
It's a substantive amendment.
Yes.
So why are we even in a hurry?
Yes.
To take consequential amendments, leaving the substantive ones, which is likely to take time.
No,
if it is two of the substantive ones that we have taken, we know that the consequential ones, we just put a question upon the proposed amendment being moved.
Yeah, so let's take the consequential amendments. And where in the proposed amendment, it is only a consequential amendment,
then I can put a question on that one.
We can take the clause as well, the entire clause as well.
Yes, so if you look at clause 51,
yes,
there is only one amendment standing in the name of the minority leader.
Yes.
If you come to clause 52, it's
so what
only
I mean
one
is that, for instance,
it's only one consequential amendment in clause 52. You come to clause 53, it's only one amendment standing in his name. And if you come to 55, it's only consequential amendment. You come to 56, one amendment. Yes. So if you take the two, we'll be able to move very fast. Yes, Minority Leader. But on this 51, there's only one amendment for me to put a question. There's no other advertised amendment. On 52, it is only consequential amendment. Very well. Clause 51 deferred. Clause 52.
Issue of summons and warrant.
Chairman of the committee.
Amendment proposed, subclause 1, line 5, delete probation and insert community service.
This is consequential. Those in favor say aye. Those against say no. The ayes have it. Proposed amendment to clause 52 is ordered to stand part of the bill. The entire clause 52, in the absence of any further amendment. Those in favor say aye. Those against say no. The ayes have it. Clause 52 is ordered to stand part of the bill. Clause 53 is deferred. Then clause 55. Clause 54.
Commission of subsequent offense.
Chairman of the committee.
Mr. Speaker, there is no advertised amendment.
It is for the consideration of the House. Honourable members, any proposed amendment? I'll put the question. Those in favor say aye. Those against say no. The ayes have it. Clause 54 is ordered to stand part of the bill. Clause 55.
Procedure before a different court.
Proposed. Subclause 3, line 1. Delete probation and insert community service.
It's consequential. Those in favor say aye. Those against say no. The ayes have it. Proposed amendment to clause 55 is ordered to stand part of the bill. Now I'll put a question on entire clause 55 in the absence of any amendment. Honourable members, any amendment? Those in favor say aye. Those against say no. The ayes have it. Clause 55 as amended is ordered to stand part of the bill. Clause 56.
56.
Procedure before a court of coordinate jurisdiction.
Yes, Chairman.
Amendment proposed, Mr. Speaker, subclause 1, lines 4 and 5. After shall, delete in the case of that court being a lower court.
Honourable members, the proposed amendment is for your consideration. Any further amendment? I will put a question. As many as are in favor say aye. Those against say no. The ayes have it. The proposed amendment is ordered to stand part of the bill. Now I put a question to entire clause 56 in the absence of any further amendment. Yes, Minority Leader.
I wanted to prompt you that there is an understanding at the front bench that upon putting the question on the entire clause 56, we draw the curtains on this today. Mr. Speaker, that is the understanding we have. I mean, Mr. Speaker, we are fatigued. And I don't want any latecomer to now come and talk 24-hour economy here. I don't want any latecomer to say anything. Mr. Speaker, that is the understanding we have.
I'll put a question. Those in favor of clause 56 say aye. Those against say no. Honourable members, the ayes have it. Clause 56 is ordered to stand part of the bill. Yes, honourable members, based on that judgment, ordinarily, if there is no proposed amendment to a clause, you go ahead to put a question. But after that judgment, you still ask the House whether there is an amendment before you go ahead and put a question. Yes, Majority Leader.
I think we've done more than 5 hours, so we're in your hands.
Very well. Then 45 are standing order 56-2. I'll proceed to adjourn the House, and the House is accordingly adjourned till Friday.
Mr. Speaker,
we'll bring consideration state to an end.
Mr. Speaker, the maze, you know you are a man of procedure.
Yes, yes.
And I'm surprised the clerk to Parliament is here.
Yes.
He's here and he knows. He has been
Consideration stage
insisting
for today
on procedure.
has
And he
ended
wanted the
on
House
the
to be
community
adjourned
service bill.
when the mills was tilted. We're still at consideration stage.
The House is accordingly adjourned till Friday, 19th June 2026.
Yes.
Oh, you are still here?
Yes, Mr. Speaker, yes. You see, there was mischief. Mr. Speaker,
the House is accordingly adjourned till Friday, 19th June 2026 at 12 noon. Thank you, honorable members.
How come the clerk to Parliament sits here and he won't check?